Arizona just revived a Civil War-era law written half a century before it became a state, banning virtually all abortions, with no exceptions for rape or incest.
The law dates back to 1864, before Arizona was a state, before women had the right to vote.
People found in violation of that law could face a mandatory 2 to 5 years in prison.
It is probably the most extreme abortion law in the country.
And the reaction so far has been intense.
This is dangerous.
There will be women in Arizona that could die because of this ruling by the Supreme Court.
It's time to fight.
So how exactly did this happen? In order for any of this to make sense, we need to first go way back to 1864. That year, before Arizona even joined the United States, their state legislature established a criminal code, which stated any person with the intention to procure the miscarriage of any woman then being with child shall be punished by imprisonment in the territorial prison for a term not less than 2 years, nor more than 5 years. Meaning, for all intents and purposes, abortion became a criminal offense. A few years later, that law was reinforced by another criminal code, which clarified that it was illegal for both mothers and physicians to take part in an abortion, unless a woman's life was in danger. And that's how it was in Arizona until 1973.
Good evening. In a landmark ruling, the Supreme Court today legalized abortions.
That federal decision that abortion was a constitutional right made this old Arizona law unenforceable. But it was never actually repealed. It just became dormant. Over the course of the next few decades, Arizona lawmakers passed, or attempted to pass, various rules on when, how, and why abortions would be allowed, including most recently in 2022.
Arizona's governor signed a controversial bill into law this week. There is now a ban on abortions in the state after 15 weeks.
Then, just 3 months after that law came into effect, the entire landscape changed.
The Supreme Court has overturned Roe v. Wade.
They have eliminated the constitutional right to an abortion.
It means it gave that power back to the individual states.
Since then, there's been a ton of confusion in Arizona about the state of abortion. The courts have been trying to come to a decision about which law should apply. The most recent law, the ban after 15 weeks, or the original law that is essentially a total ban. Since the lower courts couldn't agree, Arizona's Supreme Court had to weigh in. And this week, they found that, yes, that old 1864 law is still enforceable, writing, "Physicians are now on notice that all abortions except those necessary to save a woman's life are illegal." So how exactly did the Supreme Court come to that decision? There were two opposing legal opinions at play in this case. Some argue that the 2022 law was meant as an exemption, or an addition to the old 1864 law, essentially making it legal to have an abortion up to 15 weeks.
Our position in the litigation is that basic legal principles of interpreting statutes should have dictated that this court leave in place the 15-week policy in Arizona. The basic rules that you learn in law school are that later statutes override earlier statutes.
Others argued that because this law was passed when the right to abortion was federally protected by Roe v. Wade, the intention wasn't to legalize abortion before 15 weeks, because at the time, it was already legal. Instead, it was meant to restrict abortion as much as possible. The judges wrote it was merely Arizona's statutory mechanism for restricting and regulating Roe's abortion right.
The court said it actually was just a restriction. It criminalized abortions performed after 15 weeks gestation, unless there's a medical emergency, but it didn't affirmatively grant a right.
They made this argument in part by referring to the statement of intent the former governor filed when he passed the law in 2022, which said, "This act does not create or recognize a right to abortion, or repeal by implication or otherwise the 1864 law."
It took that as legislative desire to keep that sort of ready to come back to life, in essence, if Roe v. Wade were overturned.
2 of the 6 judges disagreed with that interpretation, and so did the former Republican governor who signed the law in 2022, writing, "The ruling today is not the outcome I would have preferred. And I call on our elected leaders to heed the will of the people and address this issue with a policy that is workable and reflective of our electorate.
And the near total Civil War era ban that continues to hang over our heads only serves to create more chaos for women and doctors in our state.
Instead of settling the issue, the ruling has raised serious concerns and created chaos for lawmakers and enforcers as they scramble to figure out what it means and what they can do about it. It's important to note that the 1864 law isn't in effect yet. It'll at least be a couple of months before it's enforceable, but the threat of what it could mean is already being felt.
I can't live with that uncertainty. I mean, we need to just focus on providing the care that our patients need.
It puts doctors in an impossible position of trying to decide whether to provide care and risk their livelihood and potentially risk incarceration.
Last year, Governor Katie Hobbs, a Democrat, signed an executive order giving all the power to enforce abortion laws to the state attorney general, essentially stripping the state's elected county attorneys of their authority to prosecute abortion cases. She says that isn't changing.
I refuse to allow extremist county prosecutors to use this abortion ban to lock up women and doctors seeking or providing needed health care.
And in turn, the Attorney General, who's also a Democrat, says she won't enforce the law, even though it mandates prison time for anyone helping provide an abortion.
No woman or doctor will be prosecuted under this draconian law.
She said her office is looking for options to make sure the law doesn't even get implemented. Now, county attorneys could challenge that order.
Some county attorneys are saying we have every right to prosecute if we want to this violations of this old abortion ban, and we intend to do so.
The thing is, this law could still be overturned in a couple of ways. One, state legislators could repeal the ban. Now, Arizona has a Republican-led legislature which so far has been in favor of abortion restrictions. But in the last couple of days, lawmakers on both sides of the aisle have come out against the ruling.
Let me be very clear. This decision cannot stand.
This is a devastating day, but we are far from being defeated.
This is outrageous that we would even dignify the consideration of this type of ban.
There's a good chance, frankly, that the legislature will simply repeal the territorial ban. That's all it takes is a one-liner, and that would then reinstate the 15-week law in full.
Another way we could see things change, and this is shaping up to be the real test, is on Election Day. There's work underway in Arizona and several other states to enshrine the right to abortion in their constitutions through ballot referendums.
That ballot initiative, if successful, would protect abortion access in the state. So we really see Arizona just being a microcosm of what is going on in the rest of the country. And it will have, I think, a significant impact on the national election in November.
If that passes in Arizona, the 1864 ban would become unconstitutional. For now, abortion clinics wait to see how all of this will play out.